Over 11 million undocumented immigrants live in the United States today, and California is home to more than 2 million of them. But starting February 2026, new federal and state level policies could drastically change everything. Entire families, longtime workers, and even students might be forced to leave the only home they've known for years. Why now? And who exactly is being targeted? Some say it's a crackdown on illegal immigration. Others believe it's a quiet political move with far-reaching human consequences. Behind closed doors, automated systems, policy shifts, and surveillance tools are already in place. And most people have no idea how close they are to being flagged. Could you or someone you know be next? In this video, we're breaking down 10 shocking reasons why thousands could be expelled from California in just weeks, and why reason number 7 might be the most disturbing of all. Stay with us. We put real work into every video, so if this helped you, just one click to subscribe means the world to us. And don't forget to drop your thoughts in the comments. We actually read them all. Number 1. Changes to Temporary Protected Status, TPS. Imagine waking up one morning and finding out that your legal protection to stay in the US has quietly vanished overnight. That's exactly what could happen to tens of thousands of immigrants in California due to the new evaluation of Temporary Protected Status, TPS, starting in February 2026. TPS was originally created to protect people from countries experiencing war, natural disasters, or humanitarian crises. For years, it allowed individuals from nations like El Salvador, Haiti, Sudan, and Honduras to live and work legally in the US. But with the new immigration review process underway, several countries are being removed from the protected list, meaning those who've built lives here, paid taxes, and raised children could be ordered to leave within months. What's more shocking, many of these changes are being made without direct notice to the affected individuals. Some immigrants may not even realize their status has changed until it's too late. Employers may be alerted before they are. And once their status expires, they lose not just legal residency, but also access to work permits, healthcare, and housing. One of the most alarming updates is the automatic expiration rule, where people whose TPS isn't renewed by a specific date will be considered out of status immediately, even if they've applied for extensions. And with processing delays and backlogs, many could get caught in a legal gray zone, flagged by immigration systems before even receiving a decision. It's not just a bureaucratic change, it's a ticking time bomb for thousands of families. The safety net they've relied on is being pulled away quietly, and unless you're watching closely, it's easy to miss the warning signs. Could you, a friend, or a neighbor be one of them? Your support fuels our content, so if this opened your eyes, smash that subscribe button and tell us your thoughts in the comments. We read every single one. Number 2, stricter documentation requirements. You'd be shocked to know that one missing paper, just one incorrect date or spelling error, could now become a reason for deportation. With the 2026 immigration overhaul, California is enforcing much stricter documentation standards, and federal agencies are doubling down on error-free compliance. What does that mean for immigrants? Everything from your work authorization, rental agreements, and even school records could be under review. And with the latest push toward AI-powered immigration audits, there's very little room for human error. A small typo on your visa application, a missed renewal date, or inconsistent information across systems can trigger a red flag in the government database. Even long-term residents with previously approved paperwork are being asked to resubmit updated documents, and this is where it gets dangerous. Not everyone understands how to properly file, and with limited access to legal support, many are unknowingly setting themselves up for removal proceedings. California's DMV, healthcare systems, and even universities are now sharing databases with federal immigration agencies thanks to interagency agreements introduced last year. This means your documents are being cross-checked constantly, and if anything doesn't match, your entire case may be reopened. Here's the twist. Many people think, my papers are good, I'm safe. But under the new rules, past mistakes are being uncovered by digital systems that weren't even in use a few years ago. A document submitted in 2015 might get flagged in 2026, and there's no grace period for fixing it. This isn't just about being undocumented. Even those with legal status are at risk if their paper trail isn't spotless. Immigration has shifted from human interviews to cold, automated judgments, and computers don't show mercy. So double check everything. Get help, because in 2026, one wrong form could cost you your life here. We dig deep to bring you real facts, so if this matters to you, hit that subscribe button and share your thoughts below. Your voice could help someone stay informed. Number 3, overstayed visas targeted aggressively. You might think an overstayed visa from years ago is water under the bridge, but under the new California federal immigration protocols, it could become your fast track to deportation in 2026. Here's what's changing. Federal agencies are using new AI-backed systems to dig through decades of visa records, flight manifests, student visas, and travel logs. Even people who overstayed for a few weeks or months, sometimes due to emergencies or paperwork delays, are now being flagged as high risk. And for many, the trigger has already been pulled. What's even more alarming is the use of biometric tracking. If you entered the US legally, your face, fingerprints, and travel history are already in the system. Now, those systems are being linked with real-time surveillance networks, allowing authorities to locate and detain individuals with expired or questionable visa histories, even if those overstays happened years ago and were never enforced until now. People who overstayed while waiting for asylum decisions, visa renewals, or green card interviews are especially at risk. Backlogged cases used to provide a cushion of time, but in 2026, that grace is gone. Immigration authorities are focusing on clearing their silent backlog of people who technically aren't legal anymore but were overlooked in previous sweeps. One case from late 2025 involved a tech worker in San Diego who overstayed a student visa by 58 days in 2018. Despite holding a job, paying taxes, and never committing a crime, he was arrested in front of his apartment without prior notice. And stories like his are becoming more common every week. So ask yourself, do you know someone who might have overstayed a visa, even by accident? If so, tell them to seek legal help immediately, because in 2026, even a temporary lapse from years ago could cost you everything. We pour hours into research to keep you informed. If this opened your eyes, hit that subscribe button and drop a comment. Your voice helps make this community stronger. Number 4, prior misdemeanors now considered deportable. Think a decade-old misdemeanor doesn't matter anymore? Think again. Under the new 2026 Immigration Enforcement Guidelines, certain minor criminal offenses that were once overlooked are now being reclassified as grounds for immediate deportation, especially in California. We're not talking about serious crimes here. We're talking about things like shoplifting, driving without a license, minor drug possession, or a DUI from years ago. Offenses that once resulted in small fines or community service are now being lumped into the public safety threat category. And once flagged, individuals are fast-tracked through the deportation process. No trial, no warning. Why the sudden shift? The federal government has given Immigration and Customs Enforcement, ICE, more freedom to revisit old records, particularly for non-citizens. California's local law enforcement databases, including county jails and court systems, are now being linked with federal review algorithms. So even if you've served your time, your name could still pop up on a digital watch list. And it gets worse. Some people don't even realize they were charged with a misdemeanor. For example, if you took a plea deal years ago just to get it over with, that record might now be used against you, regardless of your current status, employment, or family ties. One mother of 2 in Los Angeles, a permanent resident for over 15 years, was detained in late 2025 due to a misdemeanor shoplifting charge from 2011, a mistake she thought was long behind her. But under the new guidelines, that single mark was enough to place her under mandatory review. If you or someone you care about has any criminal history, even from years ago, now is the time to consult an immigration attorney, because in 2026, what you thought was behind you might come back to take everything away. We uncover the hidden truths that affect real lives. So if this meant something to you, hit subscribe and share your thoughts below. You never know who your comment might help. Number 5, sanctuary protections overridden by federal mandate. For years, California has been known as a sanctuary state, a place where undocumented immigrants could live with some level of protection from federal immigration enforcement. But that image is rapidly changing in 2026. Due to new federal mandates, many of these sanctuary protections are being quietly rolled back or outright overridden, leaving thousands of residents exposed to immediate removal. Here's what's happening. Under pressure from federal agencies, several counties and cities in California have begun cooperating with ICE, even after years of resisting. In some areas, Local law enforcement is now required to notify federal agents when a non-citizen is arrested, even for minor issues. That means a single traffic stop could result in your information being sent directly to immigration authorities. The real kicker: these changes aren't being announced publicly. Many residents still believe they're protected by outdated sanctuary laws, unaware that their city quietly changed its policies last month or last week. One moment you're protected, the next you're flagged for deportation without warning. Some areas still claim to be sanctuary jurisdictions on paper, but are cooperating behind the scenes, and thanks to new federal funding programs, cities that agree to share information with ICE are being financially rewarded, creating a dangerous incentive for local governments to shift their stance, regardless of the impact on communities. In 2026, the term sanctuary has become more of a myth than a guarantee, and for people who believed these protections would shield them indefinitely, the consequences are heartbreaking. Families are being torn apart, not because they did anything wrong, but because they trusted a system that has now changed without telling them. So if you think you're safe just because of where you live, think again. It's time to double-check the current policies in your city, because what was true last year might no longer protect you today. We work hard to uncover what others won't. So if this helped open your eyes, tap subscribe and drop a comment. Your voice could be the warning someone else needs. Number 6. Employment-based visas under review. For years, many immigrants in California have relied on employment-based visas to live and work legally in the U.S., especially in fields like tech, construction, hospitality, and agriculture. But in 2026, a major shift is happening. Employment-based visa holders are under review like never before, and for many, it could mean the end of their stay. The Department of Homeland Security has launched a nationwide audit program targeting employer compliance and visa sponsorship integrity. That means your boss's mistakes, not just yours, could now put your legal status at risk. Companies that sponsor immigrant workers are being inspected for everything from contract accuracy to tax reporting. And if anything seems off, it's the worker who suffers first. What's worse is that this crackdown isn't limited to large corporations. In 2026, even small businesses, gig economy platforms, and contract-based work are being examined. So if you're driving for a ride-share company, working under the table, or employed through informal means, you may be at greater risk than ever before. There are also new rules requiring employment-based visa holders to prove active, ongoing work, and any lapse in employment, even a few weeks, could lead to visa revocation. One H-1B worker in San Jose was placed in removal proceedings simply because their company downsized and delayed filing updated paperwork. That delay, 12 days, that's all it took. Even people who think they're protected under valid sponsorships might be surprised. If the employer is found to have violated labor laws, underpaid workers, or filed inconsistent documentation, ICE now has the authority to immediately suspend the visa with no appeal. If you're working on any kind of visa in California right now, you need to double-check your employment status, sponsor credibility, and legal protections. Because in 2026, your job isn't just about a paycheck. It could determine whether you get to stay or be forced to leave. We dig deep so you're not caught off guard. If this helped, hit subscribe and share your story in the comments. It might be exactly what someone else needs to hear. Number 7. New tech-driven deportation algorithms. This might sound like science fiction, but it's already happening. In 2026, immigration enforcement in California is being powered by AI-driven deportation algorithms. And they're scanning everything, from your social media activity to your location history. These advanced systems, developed in coordination with private tech firms, are designed to predict who might violate immigration laws or pose a risk based on behavioral patterns. The shocking part? You don't even need to commit a crime to get flagged. Simply living in a high-risk zip code, being unemployed for too long, or even sharing certain posts online could put you on a digital watch list. This isn't a conspiracy, it's policy. ICE has already confirmed that it's using predictive analytics to prioritize cases and flag potential deportees. What makes it even more dangerous is that these systems aren't 100% accurate. A glitch, a false flag, or a misread data point can lead to real people being detained, questioned, or even deported. One recent case involved a young man in Sacramento whose Facebook comments on a protest page were flagged by the system. He was called in for questioning even though he had no criminal record, a valid visa, and a stable job. His online activity was deemed potentially disruptive, and that was enough to trigger the system. This kind of digital profiling is quietly expanding, and most people don't even realize they're being monitored. Algorithms don't ask for context, and they don't understand nuance, which means your tweets, Instagram posts, or even old emails could be taken the wrong way. In 2026, your digital identity is just as important as your legal paperwork. If you're an immigrant in California, today, it's time to be extremely mindful of your online presence, associations, and digital footprint because these systems are watching, learning, and deciding who stays and who goes. We break down what others ignore. If this gave you a new perspective, tap subscribe and share your thoughts below. Your voice might spark someone else's awareness. Number 8. Family-based petitions under backlog pressure. In 2026, one of the most unexpected and dangerous triggers for deportation in California is the massive delay in family-based immigration petitions. These include applications where U.S. citizens or green card holders sponsor spouses, children, parents, or siblings for legal residency. Due to system-wide backlogs, many of these applications have been stuck in processing for 5 to 7 years, especially for countries with high demand. But under the new enforcement strategy, individuals with pending petitions are being reviewed more strictly, and if their temporary visas expire while waiting, they may be labeled as out of status. Even if someone applied legally and followed all the rules, if they're still waiting without an approved petition, their removal proceedings can begin. This applies to people on student visas, visitor visas, and work permits that have run out during the wait. No automatic protection is guaranteed under the new rules. Additionally, renewals of work permits linked to pending petitions are now being delayed or denied in many cases, leaving applicants without legal employment and pushing them into deportable status faster than ever before. This shift isn't based on new crimes or violations. It's a technical failure of the system. But individuals and families are bearing the consequences. If your legal status depends on a pending family petition, it's now critical to consult an immigration attorney and explore backup options. We report facts that matter, so if you found this valuable, click subscribe and comment below to keep the conversation real and informed. Number 9. Crackdown on public assistance usage. One of the most controversial changes in the 2026 immigration enforcement strategy is the renewed focus on the public charge rule, a policy that allows immigration authorities to deny or revoke status if an individual is deemed likely to rely on government assistance. And in California, this rule is being applied more aggressively than ever before. The public charge rule has existed for decades, but in 2026, it's being expanded and enforced in ways that are catching many immigrants off guard. Under the new guidelines, using certain benefits, even temporarily or legally, can now lead to denials of visa renewals, green card applications, or even deportation proceedings. This includes programs like Medicaid, food stamps, CalFresh, Section 8 housing, and even some school-based aid. Immigrants who received any of these benefits in the past few years, even during emergencies like COVID-19, are being flagged for review under updated risk scoring models. What's even more concerning is the lack of clarity around which benefits are considered a public charge factor. Many families, including those with U.S. citizen children, are now avoiding essential support out of fear that it could be used against them in the future. In some cases, benefits legally accessed by a dependent like a child are still being counted against the parent or guardian. Authorities are now using data sharing systems between state and federal agencies to identify individuals who have accessed public benefits. If matched to a non-citizen file, that information can be used as evidence in removal cases, even if the person is fully compliant with other immigration requirements. The message in 2026 is clear. Any association with public assistance can now carry immigration consequences. Immigrants in California should be extremely cautious and consult legal experts before applying for any government help. Even if they're eligible, we bring clarity where it's most needed. So if this helped you or someone you know, hit subscribe and share your insights in the comments. Your experience could guide others through the noise. Number 10. Mass data sharing between California and federal agencies. One of the most overlooked dangers in 2026's immigration crackdown is the massive increase in data sharing between California's state systems and federal immigration authorities. What used to be separate and protected records are now part of a centralized enforcement network, quietly connecting your personal information to federal databases and potentially triggering deportation. This includes data from the California DMV, state healthcare programs, public schools, university systems, and even tax filings. Thanks to new cooperation agreements and technology upgrades, agencies like ICE and USCIS now have access to real-time data on millions of residents. If your visa has expired, your work permit wasn't renewed, or your name appears in multiple systems with discrepancies, you could be flagged automatically without ever receiving a call or letter. What's most concerning is that many people don't even realize what information the state holds. For instance, when you applied for a driver's license, enrolled a child in school, or visited a public clinic, that information was collected for state services, but in 2026, those same records may now be reviewed for immigration enforcement purposes. Even undocumented residents who once felt protected by California's sanctuary policies are being impacted. Several local jurisdictions have now agreed to share certain data sets with federal agencies in exchange for funding, infrastructure support, or compliance with national security standards. Data isn't just being shared, it's being cross-referenced, scored, and analyzed by artificial intelligence. If your file shows inconsistencies like mismatched addresses, expired identification, or old benefit records, it can trigger a targeted review without human oversight. This means people are being flagged by algorithms and entered into deportation proceedings without warning or due process. In 2026, your data is your risk. That's why every immigrant in California should know exactly what records they've submitted, where they've submitted them, and how that data could now be used against them. We connect the dots others don't. If this gave you insight, subscribe now and share your thoughts below to keep others aware and protected. As we've seen, February 2026 marks a turning point for immigration in California. And for millions of people, it's not just about policies on paper, but real-life consequences that could change everything overnight. From stricter documentation checks and AI surveillance to the rollback of sanctuary protections and hidden data sharing agreements, the rules are shifting fast and not always transparently. What once provided safety or a path to legal residency is now being used as a tool for enforcement, whether it's a past visa overstay, the use of public benefits, or simply being stuck in a backlog. The margin for error is shrinking, while the systems tracking these errors are expanding rapidly. This isn't just about undocumented individuals. Even people who followed every step of the legal process, workers, students, parents, and spouses are being caught in the crossfire of a system that's becoming more automated, aggressive, and unforgiving. So what can you do? Stay informed about changes in both state and federal policy. Double-check your documentation and legal status regularly. Avoid risky situations, even if they seem harmless. Consult a qualified immigration attorney for personalized advice. And most importantly, share this information with your community, because the more we know, the better we can protect ourselves and others from unexpected consequences. We'll continue covering these developments with facts, clarity, and urgency, so you're never left in the dark. If you found this valuable, just one click to subscribe helps us keep going, and your comment could be the update someone else urgently needs.